The other major exception you mentioned is money, that money is one's personal property, or there's some value that you have, but under current regulation and current legal review, money is not considered property subject to the takings clause.
Well, that might be a little overbroad, but what I would say is that the government finds lots of ways to characterize things as taxes or regulatory fees, licensing fees, in such a way that they avoid kind of the takings analysis. At some point, when the government acts, they can go down different routes with things. And I would suggest that in this day and age, and under the Supreme Court case law, and under the various states' case law, a lot of times, if they can take something and say, this is a tax, even though they're taking money, which is personal property, undoubtedly, they get away with it under the logic that, well, that's a tax. It's just a tax, and taxes aren't subject to the takings analysis.
Okay.
The problem I have with that is that if you look at what taxes should be used for, this goes back to the whole what is the proper scope of government problem.
Sure. Okay.
When you're taking taxes and doing things with them that are beyond the legitimate purposes of government, and it's basically the government taking money for other purposes, at that point I would say you have a taking of money.
I see. All right, so as you mentioned here, a lot of this has to do with politics, and there's an ongoing debate about what the scope of private markets and private property should be relative to government use and government property. Over and beyond that, the issue then is as the powers of takings become expanded, and in some cases the terms become less defined, or at least more loosely defined, it opens up doors for people to come in who are private parties, but who are politically connected then to use the newly expanded or the vague language to benefit themselves privately at the expense of other private property, or parties rather. To what extent has that been a feature of late 20th century property rights and takings cases?
Well, I think that happens a good amount. Certainly happens more than it should. For example, we see in the Kelo case, and that's central to that case, what's really going to happen with that property is the development that's going to go there arguably is a public interest, is a private use, but some other private property is going to benefit. And we have the Supreme Court saying that, well, the mere fact that some other private party is going to possibly benefit from this transfer of the property, that's okay. There's a case involving Amtrak, for example, where Amtrak is running on a line owned by one railway, and they say, well, that railway is not maintaining the line. Interstate Commerce Commission, we would like you to, since they didn't accept our offer, Amtrak's offer to buy that stretch of line, we would like you to buy that, or I'm sorry, exercise eminent domain to take that stretch of railway, transfer it, in effect, after all the transferring is done, transfer it to this other railway, who will then own it and lease it to Amtrak. And that's where we see the first railway was probably asking some market price for this property. It should, the property being the railway, it probably should have been able to get whatever the market would bear for that stretch of railway. Instead, the government intervenes, takes the railway, in effect, gives it to some other private railway is the desired outcome in the case, and benefits that other railway.
Okay. In your more personal, obviously there are lots of eminent domain cases and taking clauses around the nation, like the Kelo case, that have made national attention. In your experience, while the process is no doubt messy, to what extent do you think the eminent domain cases that come up are legitimate ongoing debates over what counts as proper public use or public interest versus private interest? And what percentage of the cases, to what extent are the cases really a matter of some private parties who are connected using the system to their own advantage?
I would say that the cases that get the most notoriety are those, the sorts of cases you're talking about.
Sure.
So that kind of distorts the perception of them.
Okay.
I'm not a fan of those cases, so I'm not suggesting that they don't go on, or I'm not trying to shove them aside. But I would say that eminent domain goes on roughly on probably a daily basis, because you have all kinds of instances where all kinds of governmental entities, utilities are taking usually little swatches of property, taking easements in property to run pipes or to run power lines, things like that. And that goes on daily. And how many of the cases actually turn into what you're talking about? Probably a very small minority. But it's those cases that really have an impact on this whole debate over what is public use, what is legitimate public interest,
Right.
what the boundaries are, and whether one private party gets to persuade, lobby, somehow get the government to act on its behalf, to act as a taker of property on its behalf, because it's undisputed under United States law, that, and probably under English common law, that there is no mechanism by which a sovereign is supposed to directly take property from landowner A and just directly give it to landowner B.
Right.
And what we've set up is this entire subterfuge of, well, it's economic development and it's in the public interest, and so even though some other private party is going to benefit, that's okay. And I would say that the dollar magnitude of those cases, even though they're kind of a smaller number of the cases, like I was saying, the dollar magnitude is probably higher, in that that's where something's at stake.
Right.
That's where huge amounts of things are at stake.
And so the interests then are set up for using the system right in that particular fashion. Okay.
Right.
All right. Well, thanks for being with us today. That was a very interesting talk. Nicely informed. Thanks.
Thank you for having me.